Now, whether any amendment which is made to the provision of Constitution of India can be made applicable to the state of Jammu and Kashmir. The answer is provided by proviso to clause 2 of Article 368 of the Constitution of India, which clearly says that amendment to the constitutional provision can be made applicable to the state of Jammu and Kashmir if the President by order may specify after fulfilling all the conditions of Article 370 of the Constitution of India. Now the question is, what is the extent of autonomy which is enjoyed by the state of Jammu and Kashmir? As we all know that various orders have been passed from time to time under Article 370 of the Constitution of India. The Constitution, application of Jammu and Kashmir Order 1950 as well as the Delhi Agreement 1952 govern the relationship of Union of India as well as the state of Jammu and Kashmir. Subsequently, various orders have been passed, whereby the laws have been made on all the matters which are given in the Union list and are made applicable to the state of Jammu and Kashmir. The President, application to Jammu and Kashmir Order 1954. It endorses the relationship defined in Delhi Agreement 1952. This order, that is the order of 1952, superseded the President application to Jammu and Kashmir Order 1950. By virtue of this order of 1950, Article 35A was inserted to the Constitution of India. Article 35A has given power to the State Assembly of Jammu and Kashmir to define the term permanent resident. The term permanent resident has been defined by the State Assembly as a person who was a state subject on May 14, 1954 or who had been residing for a period of 10 years and had acquired immovable property in the state of Jammu and Kashmir. Now, various special rights have been given to these permanent residents relating to employment, jobs, scholarship, aids, as well as the right to property. Now, these rights which have been made applicable, or you can say the rights which have been given to the permanent residents, they are not given to the non-residents there. However, various constitutional laws have been made applicable in the state of Jammu and Kashmir, which was considered by few of the people as dilution of the autonomy which is given to the state of Jammu and Kashmir. But there are certain specific rights which I have already discussed which have been given to the permanent residents but not to the non-residents. This has restricted the autonomy which has been granted to the state of Jammu and Kashmir. But nevertheless, I have already discussed that there are certain rights which are available to the permanent residents but not available to the non-residents. For example, the permanent residents, they have the right to acquire immovable property in the state of Jammu and Kashmir. But the other people, that is the non-residents, they do not have such rights. Then the emergency provisions in case of the internal disturbance is also not applicable in the state of Jammu and Kashmir and is applicable only with the consultation of the state government. The directive principles of state policy are also not applicable in the state of Jammu and Kashmir. However, the fundamental rights which are given in the Constitution of India, they are applicable in the state of Jammu and Kashmir but subject to certain modifications. So, in the end, I can only say that still, even after so many restrictions, or you can say after so many laws being made applicable or so many provisions being made applicable in the state of Jammu and Kashmir, yet the state of Jammu and Kashmir still constitutes a special categories as compared to the other states of India.